what? All right, so you've been sued by a debt collector or creditor. Now, what? First thing I want you to understand is this is not the time to panic, but it's definitely not the time to ignore it either. Getting sued doesn't automatically mean they win. A lot of people think that, oh, because they filed suit, that means they have so much on me and that they're so confident. No, getting sued does not automatically mean they win. It means somebody filed a claim against you, and now there is a court process that has to happen. That's all that means, right? And what you do at the very beginning can completely change how the rest of this case plays out. So, in this lesson, we're going to talk about those first moves. The clock started the day you were served. The first thing I want you looking for is your deadline. Once you were served, that clock started. So, depending on where you live and how you were served, you probably got around 20 to 35 days to respond. So, look for that date immediately and make sure you're in that deadline. Um, so don't put the paperwork on the counter and say, "Oh, I'll get to it next week." Pull the paperwork out, find the court, find the case number, find the date you were served, and figure out exactly where your response is due. I'm sorry, when your response is due. Okay. Before you walk into that courtroom, you have to still be in the fight. Okay? You have to still be in the fight. Ignoring is still a decision. Okay? Ignoring is still a decision. And going back to this slide too, I want to talk about when we talk about your answer. Some courts, 9 times out of 10, if you're being sued by a debt, especially by a debt collector or a creditor, 9 times out of 10, your case is being seen in small claims court, right? So in the description box below, I have my no surrender litigation plan where I walk you step by step from the moment you get the summons to the moment your case gets dismissed in court. And I also, it's like a side by side. So if you're dealing with this court or if you're dealing with that court, but 9 times out of 10, you're dealing with small claims court, which is lenient. So most of the time, probably all of the time, you're not, or most of the time, I'm not going to say all the time, most of the time, most states, you're not going to, they don't do filing an answer, like filing it actually with the court. You just show up and you just plead your case right then and there. I still went over again, because I went over if you're being sued in small claims court or if you're being sued in a higher court in those rules. But I want to mention that I still want you to do the answer. I still want you to write it out, not only just to get a feel for it, but because those affirmative defenses in there, they're just going to be what you say out loud. Okay, you can respond to the deadline, but when you get in there, it's like, yeah, you can answer, but what are you going to say when you get in there? You still have to raise certain defenses. Again, small claims court is different, but I do know in a higher court, if you have to file an answer, if those affirmative defenses are not in that answer, you may raise your right to raise them later on in the argument. So, okay, moving on. Ignoring is still a decision. So one of the biggest mistakes people make is ignoring the lawsuit because they're scared or they think court is so intimidating, but ignoring it does not make it disappear. So if you don't respond, the other side is going to get that judgment. You can be sure of that and understand what that means, because I don't think people understand what that means. That means without even having to prove anything, because the judge is not going to say, oh, well, the other party's not here, so, you go ahead and plead your case. No, the judge is not there to work on your behalf. You have to work on your behalf. So you don't want to show up, default judgment, right? That means you never even made them show their hand. That's why showing up and responding matters, y'all. Stop ignoring these lawsuits, okay? What a judgment can turn into. Now, this is super important, right? A judgment is not just a piece of paper saying somebody won, okay? Them people are coming to collect on their money. And depending on your state, in your situation, a judgment can turn into a wage garnishment, a bank account levy, or a property lien. And I actually had someone in my school community, and y'all, I'm not even the original creditor, but a third-party debt collector put a lien on her property. Now, here's the thing. With a lien on her property, first of all, she knew she was being sued, but it was years prior, and she never showed up, and she thought, okay, maybe it'll go away, type of, catch me if they can type of deal. And it's like they already caught you because, again, they got that judgment, and with that judgment, whatever they find on you, they can start again is garnishing your wages, coming after your bank accounts, or putting liens on your assets. So when somebody says it's just a little old credit card bill, I want you to understand that once that debt makes its way to court, we're dealing with something completely different here. Okay, so this is why you want to deal with the lawsuit before it gets to the judgment stage. Okay, read the complaint like it is evidence, because it is. All right, before you start downloading templates and writing all kinds of stuff to the court, I need you to read the complaint. And I mean, like, actually read the complaint, like who's suing you, how much are they claiming you owe, what exactly are they saying happened, and probably one of the biggest questions, what did they actually attach to prove it? Because that's really the biggest thing. They could say all of these things, but what did they attach? Don't automatically fill in the blanks for them. If something is missing, you need to notice that. Sorry, y'all. Hold on. If something is missing, you need to notice that, right? If something doesn't make sense, if the plaintiff is a company that you've never heard of or you've never even seen on your credit report, that's issues, right? And you need to be there. This is why showing up is so important. You need to be there to address that. Okay. An answer is not an argument. It is a response. Oh, I'm sorry, y'all. All right. So this is where people sometimes make this harder than it has to be. Your answer is not the trial, okay? You're not supposed to write a 10-page story explaining your entire life and what happened and why you did it and all of this other stuff. You're responding to what they allege. They say this, how do you respond? They say that, how do you respond? And then look at what defenses may actually apply to the situation. So if you're like, I don't know what defenses I'm supposed to raise, whether in my answer or verbally, when it's time for me to fight this, you need the no surrender litigation kit in the description box below. This is why I don't want you to just copy somebody else's answer off the internet, right? Their case is not necessarily your case. And this it really goes for credit repair too. So you need to understand what the plaintiff actually alleged and what your response to those allegations is. Because I am so sorry, y'all. Because every defense that you could raise isn't necessarily what applies in your situation. Okay? Oh, I'm going to get through this. The plaintiff carries the burden of proof. Now, this is the part I really want you to remember. The plaintiff brought the lawsuit. That creditor, that debt collector brought the lawsuit. That means they have the case and they have to prove it. A lot of people walk into court acting like the whole burden. Whew. What? Ooh. Acting like, whew. Acting like everything falls on them to prove they don't owe the debt. No. It's actually the opposite. Start asking questions. What evidence are they relying on? If they have witnesses, sometimes they'll bring witnesses. Normally in a higher court, but sometimes they'll bring witnesses. Question that witness. Even in the litigation, the no surrender litigation plan, I go over cross-examining witnesses if they bring it, what the judge would might ask you. 9 times out of 10 going to ask you how to respond, like all of these things, tearing apart their evidence, all of those things are in there, y'all. So if this is a debt buyer, Also, how are they connecting themselves to the original account? Because 9 times out of 10, they don't have anything showing that they purchased your specific account. Where is the documentation supporting the amount? So most people never get that far though, because they just either don't respond, or they're so afraid of court that they just never make the plaintiff actually prove the case that they filed. Right? Know your next move before the deadline hits, y'all. And this is exactly why I created the Go to University, right? I don't want you sitting at home with court papers, Googling random answers, or ignoring it completely and just going about your life, or staying up 2 o'clock in the morning trying to figure it all out the morning of. Inside the community, we break this process down step by step. We also, I also do it. We do everything deep dive in the school community, but it's also in that litigation plan, and you need that if you are being sued by a creditor or a debt collector. Like right now, you can go ahead and skip this. Go to the description box below and download your copy now. We go over understanding the lawsuit, understanding your response, knowing what paperwork to look for, understanding defenses, learning how to challenge their evidence, learning how to prepare for court. That's a big thing too. Learning how to question your witnesses. And what else? And we also just go over like understanding what is happening instead of just walking into that courtroom completely blind. So if you're dealing with a lawsuit right now, please do not wait until the deadline is here and it's the morning of, and you're just now trying to figure out what does this mean, and was I supposed to answer, was I not supposed to answer, trying to clog up the system, the court clerk phone, trying to get them on the phone. You frustrated because they not answering. It's a long wait. Listen, get educated, get prepared, and know your next move. With that being said, I will see y'all in the next class with a way less coughing, y'all.